New York real estate exam cheat sheet. Let's get started. A property manager in Staten Island collects rents and handles maintenance for an apartment building. Under New York property management, do they need a real estate license? Is it A, no, if employed by owner? Or B, yes, always? Could it be C, no, for residential only? Or lastly, D, yes, if handling leases? The correct answer is A. Here is why. New York real property law requires a real estate license for property management activities including renting, leasing, and collecting rents. However, an employee of the property owner who manages the owner's own property does not require a license if no third-party brokerage activities are performed. Option A is correct. Option B is incorrect. The employee exemption exists. Option C is incorrect. Residential property management requires a license unless employed by owner. Option D is incorrect. Handling leases is a licensable activity, but the employee exemption applies. Next question. A commercial lease in Manhattan includes a clause for rent escalation based on the Consumer Price Index. The tenant disputes the calculation. Under New York lease contracts, how is this typically resolved? Is it A, through arbitration if specified? Or B, by the landlord's discretion? Could it be C, in small claims court? Or lastly, D, automatically in favor of the tenant? The correct answer is A. Here is why. Commercial leases often contain alternative dispute resolution provisions, including arbitration, for resolving calculation disputes. If the lease specifies arbitration, that is the typical resolution mechanism. Option A is correct. Option B is incorrect. Landlords do not have unilateral discretion. Option C is incorrect. Small claims court has jurisdictional limits and is not typical for commercial lease disputes. Option D is incorrect. There is no automatic presumption. Next question. During a transaction in Long Island, the listing agent learns from the seller that the property has a history of minor flooding in the basement during heavy rain, though it has been mitigated with sump pumps. The agent does not disclose this to the prospective buyer because it is not a structural defect. Under New York property disclosure and material fact rules, has the agent met their obligation? Is it A, yes, only major structural defects require disclosure? Or B, no, known material defects affecting value or desirability, including water intrusion history, must be disclosed even if mitigated? Could it be C, disclosure is only required if the buyer asks about flooding? Or lastly, D, the Property Condition Disclosure Act exempts agents from liability for seller-provided information? The correct answer is B. Here is why. Water intrusion history is a material fact affecting value and desirability. While New York adheres to caveat emptor for sellers, licensees have an affirmative duty to disclose known material defects and cannot remain silent. Option B is correct. Option A is incorrect. Materiality is not limited to structural defects. Option C is incorrect. Disclosure is required regardless of inquiry. Option D is incorrect. Agents may be liable for non-disclosure of known facts. Next question. In Buffalo, the City Planning Board reviews a proposal for a new shopping center. Under New York municipal agencies, what is their role? Is it A, issue building permits? Or B, approve site plans? Could it be C, collect taxes? Or lastly, D, enforce zoning? The correct answer is B. Here is why. Planning boards typically review and approve site plans, subdivisions, and other development applications. Option B is correct. Option A is incorrect. Building departments issue permits. Option C is incorrect. Tax assessors/collectors handle taxation. Option D is incorrect. Zoning boards of appeals hear variances and appeals. Enforcement is by code officials. Next question. A homeowner in Rochester discovers lead paint during a renovation of a pre-1978 home. Under New York construction and environmental issues, what must they do if selling? Is it A, remove all lead paint? Or B, disclose to buyers? Could it be C, ignore if not visible? Or lastly, D, only test if children involved? The correct answer is B. Here is why. Federal Title X and EPA regulations require sellers and landlords of pre-1978 housing to disclose known lead-based paint hazards and provide the EPA pamphlet to purchasers/lessees. Option B is correct. Option A is incorrect. Removal is not required. Disclosure and opportunity to inspect are required. Option C is incorrect. Non-disclosure is a violation. Option D is incorrect. Disclosure is required regardless of children's presence. Next question. In Rochester, a landlord refuses to rent an apartment to a tenant because they have a service animal for a disability. This action violates which New York legal protection? Is it A, human rights law? Or B, rent stabilization code? Could it be C, multiple dwelling law? Or lastly, D, zoning ordinance? The correct answer is A. Here is why. The New York State human rights law and local human rights laws prohibit discrimination based on disability, including the refusal to accommodate service animals. Option A is correct. Option B is incorrect. Rent stabilization code governs rent regulation. Option C is incorrect. Multiple dwelling law addresses building construction and maintenance standards. Option D is incorrect. Zoning ordinances regulate land use. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.